All right, welcome everybody. Today's guest is Michael Hanahan. Most of you guys know him or know of him. Actually, before we started recording, Michael and I were talking about my experience in the community is that about a third of the folks call his lectures on pro practice the Hanahan lectures. About a third call them the Schiff Harden lectures because he used to be an attorney at a firm called Schiff Harden. He's since moved to Perkins Coie, and about a third of people call them the Perkins Coie lectures. And it occurs to us that maybe we should give them one name. And it occurs to me that there are 200 of you on the call right now. Maybe you should come up with a name. You guys are creative. Collectively, you're smarter than any of us. So if you have a name suggestion for Michael Hanahan, Schiff Harden, Perkins Coie lectures, that's a little bit more memorable and maybe a little bit more tied to him or pro practice, then come up with a name, and he doesn't have to look at the chat. We'll compile the names and email them to him, your suggestions. Anyhow, so most of you guys know him. Michael is an attorney. If you are ever involved in a lawsuit or don't want to be, I would encourage you to tell your firm to hire him. I don't know that I would ever want to go against him in any kind of a dispute. And he's joined us he comes to us about every 6 months. And that happens to be today. And we've given him a bunch of questions as kind of a blitz. So we'll go ahead and start with the first one. The first one is, on a construction site, a subcontractor laborer asked an architect to fetch a wheelbarrow. The wheelbarrow was set down behind the laborer. The architect let him know verbally that it was there. The laborer, forgetting about the wheelbarrow behind him, backed up, fell over the wheelbarrow, and was seriously injured. Whose insurance and which type of insurance policy, workers' comp, general liability, professional liability, would cover this? And then we'll get to the second part of this in a minute. So, Mike, do you have a definitive or a ambiguous answer for us?
Well, as those who have listened to my lecture, the two words that I like the most, and most lawyers do, is it depends. But the reality here is what I want to start out with is first is the architect shouldn't be obliging the worker and fetching the wheelbarrow. One of the things that you want to do is you want to stay away from issues that would fall into the performance of services on a construction project that are outside of the services that you would be doing as the architect. Once you start doing those, you've actually, by your actions, stepped out of protections that are going to be in your contract. And the protections are in there, they're standard in the industry, and they're there to keep you from being in a situation like this where you and or your firm could be exposed for liability. So that's the first kind of, even though you're a nice person and you want to make sure that you're trying to help things out, if one of the workers asks you to perform a service that they should be doing, you got to tell them no. So that's your first thing. As to if the injury, when the injury happens and there's a lawsuit, because we live in America, they're going to sue everybody, your firm's going to be brought in. And the question is which insurance and which types of policy would come into play? Interestingly enough, I was having a discussion just today, with my coverage counsel on this whole concept of whether you're going to be, it's going to be comp, whether it's going to be the workers' comp policy, general liability, and where would it kick in? Now, our discussion was about the owner and the contractor as opposed to the architect and the contractor, but some of the same things apply. There will be an application, or should be an application, by the injured worker to their workers' compensation policy. And that's something that's going to be statutory in every state in the country. And so there is a payout by the workers' comp, or there should be a payout by the workers' comp carrier to the injured workers. And in each state, there's going to be a schedule and a chart. And it's going to say the value of a lost finger is X, the value of a hurt back is Y, the value of a broken leg is Z. And so it's a statutorily, from state to state, regulated about how much one part of your body and what type of injury is worth. And that's going to be a payout. The next question, though, is what happens if the injuries are significantly greater than the value of the workers' comp payout? Who's going to kick in there? And that's when it's going to happen is because it's a subcontractor laborer, and the way workers' comp insurance works is once the comp is paid out, the subcontractor's employer will not have to pay any more. That's why they carry workers' compensation insurance. So then it would turn to should the general contractor be responsible or could the architect be responsible? And in this case, I would argue that maybe the general contractor could have some liability, but let's just focus now on what happens for the architect, because that's what we're here mostly talking about architects. In that instance, if the architect had a claim against it and tendered it to their carrier, the professional liability carrier would deny coverage. There would be no payment made under the professional liability because, as I said in the very beginning, you are now performing services that are not services that an architect or engineer would normally do. You're not doing design professional services, and the professional liability policy specifically excludes. There's language in the policy that says we exclude services or work or actions performed or taken by the insured, here the architect, that are not professional services. So the professional liability will not cover. So then it falls back to, will the architect's general liability policy cover? And the question is, it may or may not. That's why I said it depends. In normal instances, your GL policy would be covering for work that you did normally on your project, where your offices would be. And could the policy be enough that it covers you walking around on the project site? I think you could make a good argument. You would have to look at the language of the policy. But let's take it a little bit differently, and where I would try to push your carrier, if you're the architect, to pay under the general liability policy. Let's say it wasn't that you moved the wheelbarrow. Let's say you were turning a corner around a blind corner and you ran into someone, so it was negligence, you didn't know what happened, and that person fell down and broke their leg. Well, it was an accident, and that would be something potentially, but you were the one that caused it because you ran into the person. It wasn't intentional. So you would try to make the argument to your carrier that under the general liability policy, you were the cause of this person's injury and they should cover you as opposed to you having to pay out of your own pocket. I think that that could be an argument that would keep your GL policy in place, and that you would try to make that same thing here when you were acting where I say outside of your scope is by putting in the wheelbarrow. I am not familiar with or aware of general liability policies that say we can deny coverage if, in fact, you acted like a general contractor here or a subcontractor and started doing scope services like providing a wheelbarrow. So I think where ultimately it would land is the comp would pay first, and that would be from the employer. And then you would be, as the architect, asking your carrier under the general liability policy to pay. So that's the overall answer to that first part of the question.
Okay, and then what if that's super interesting. So wait, before I go to the next question, let me make sure I understand. So the subcontractor's workers' comp would pay first.
Yes.
Then but anyone could take anyone to court. So if the expenses or the pain and suffering or whatever was greater, if there was someone to sue, it would be possibly the architect's general liability that may kick in. But of course, the architect is not supposed to be doing things like that on the site because materials and methods of construction are the purview of the contractor. Correct. And if the architect had, by something more affirmative or direct, actually caused the injury, of course unintentionally, so there wasn't like some kind of weird like criminal intent or something, but the architect had caused the injury, and then it would still be the workers' comp it would still be the same thing basically, but it would just be an easier call. Yes,
and what'll happen on the comp carrier, let's say they pay out $300,000 for the injury that they have because statutorily that's what they would pay. Is what would happen in the actual lawsuit, the comp carrier, if the jury or judge found that the sole liability was due to the architect's performance here, and arguably it's not just that, because the architect has said, hey, there's a wheelbarrow behind you, and the worker assumed some of its own risk by forgetting about it. So the architect's can say, it wasn't my fault entirely. In fact, I told him about it, but they're still going to be stuck in there. But let's say it was the architect that solely was responsible. The comp carrier is going to bring a claim under subrogation against the architect as well and says, you have to pay the whole $1 million in damages and give me my $300,000 back. The injured party, the worker, already has the $300,000, but you have to pay the full $1 million and give me my money back. That's a subrogation claim.
Interesting.
In this case, it would probably be split. There would be the 300,000 plus if it's $1 million verdict, then there would be the 700,000 remaining would have to be picked up by the architect, by their general liability policy carrier.
And what if there was a structural engineer that was walking the site with the architect, and it was a structural engineer who ran into the labor and knocked him down the hole, and he broke his leg? Then who covers what?
So in that instance, it's actually going to be pretty much the same. The subcontractor, in this case, it's the consultant hired by the architect. They are going to be that injured worker still can look back to its own employer. So, structural engineer company A, the worker that works for that will say to its own carrier, hey, I have a comp claim. I got injured on the job. So at least they get the money for their medical damages and whatever the value of the injury is. But there's one little nuance that would come in here. It's very likely that the subcontractor could be named as an additional insured on the architect's general liability policy. And it would be also reciprocal, where the architect could be named as an additional insured on the subconsultant's policy. And so in that instance, what happens is you look at the language of the insurance writer, and the way I would write this is I would say, I, architect, am hiring you, structural engineer. You need to carry the following insurance on the project: comp, workers, general liability, auto, blah, blah, blah. And in the general liability, I would say, you must name me as the architect, as an additional insured, and your general liability policy shall be primary and non-contributory to mine. And so in that instance, if you have the primary and non-contributory language, when the architect gets sued by the injured structural engineer, yes, potentially the architect's general liability policy would pay, but because the architect is named as an additional insured on the structural engineer's policy, and that structural engineer's policy is primary, then you would say your insurance company needs to pay first under the general liability. And then you get into the question about whether they've paid out fully on the comp and if there's something else. So there's some questions where the architect maybe could insulate itself from liability because of the primary and non-contributory language that's there. So
okay, so just to make sure I understand this, first of all, why don't you tell us what an additional insured is?
Okay, so an additional insured is when you get an insurance policy, and it could only be on certain policies, you as the let's call it, you're the primary party, party A, you retain or you enter into a contract with party B. And you say to party B, I want you to carry these types of insurance. And so you as party A also probably have the same type of insurance for your business, but because you're hiring someone and you're paying them to do that and you're paying for their insurance, you say, name my company on your policy as an additional insured. And what that does is it gives company A the full benefits. They are a beneficiary of company B's policy. And so when an injury happens, when there's a damage, when there's a claim, company A says, company B, your policy, because I'm an additional insured, triggers first, and I get the benefit of it because I'm a beneficiary. And let's say it's $1 million policy, maybe the injury is worth $2 million. Well, the first $1 million comes out of company B's insurance because you're named as an additional insured on that, it's primary. And then anything left over may fall or waterfall down to company A's insurance. But as an additional insured, you are the beneficiary of that party's insurance, just like they are. You're just like a named insured for theirs.
And in this situation, or most situations, the company that's hiring is getting the baby company, the parent company. I'm calling it a parent and a baby.
Yes.
The parent company is getting the baby company to insure the parent.
Yes, and the reason why, and especially certainly at the owner contractor or owner architect level, the reason why is because when the architect gives their price to the owner to do the project, built into their fees is the value of their insurance premium. So effectively, owners saying, I'm paying for your insurance on this project anyway. For you to insure yourself, you're passing along those premiums to me, and I'm paying those. So I should get the benefit of those just like you do. If I'm the one that's helping you pay your policy premiums, I should get the benefit too, to make sure I'm protected. Now, the one nuance I will say here, and we're only talking about probably because this is not design services, these are non-design services, you can be named as an additional insured on a general liability, on auto, and on workers' comp. An owner will not be named as an additional insured on the professional liability policy. And the reason why is because the owner's never going to be providing professional services. So why would I be getting the benefit of insurance that protects architectural design services when I'm not doing architectural design services? So you can't be named, you normally aren't named as a additional insured on professional liability. Now, if the owner, or it may be in the instance where the architect hires a structural engineer, since you are both providing professional design services, there can be, in certain instances, additional insured status on a professional liability policy, but it's much less common.
And so, just to be clear again, so if I'm walking with a structural engineer and I'm an architect and I fall down the hole I'm added to I'm an additional insured. Tell me again the phrase, because I've been asked to do it before and I can never remember.
Insured.
I'm an additional insured on the structural engineer's policy. If I fall down the hole as an architect, will the structural engineer's policy in part cover me?
If you fell down and it had nothing to do with the structural engineer, no, because there's no liability on the structural engineer's part. So the insurance companies only kick in when there's liability. Now, sometimes they'll pay before a judgment by a jury, but no insurance company is going to pay if there's a full defense. So the insurance is if the structural engineer bumped you by accident, you fell in, then their general liability policy would kick in, and you would say, I want the additional insured status from that because there was this accident that caused it. But if you're just walking by and because you had your head in the clouds and you fell in a hole, then your suit would probably be against the general contractor because they should have put a barrier around that hole or whatever.
Gotcha. All right, let's move on to our second question. In a standard owner-architect agreement for a brownfield, should the architect promise to meet life safety, zoning, and accessibility requirements? Should the owner in that particular owner-architect contract promise to address any toxins that may be found on the site? Should the architect in that particular owner-architect contract promise to address any toxins that are hazardous materials that may be found on the site?
Okay. So as I jokingly, when you sent me these questions the other day, I jokingly went back and said, well, what's a standard owner-architect agreement? But let's just take, for example, the AIA contract.
I think that, we're not only are we all familiar with it, but that's what the exam will covers.
Yep. So let's take the owner-architect agreement, the either whether it's the B101 or one of the other ones that we'll talk about that. So in a brownfield, or even if it's a greenfield, what the architect should not necessarily promise to meet life safety, zoning, and accessibility requirements. What the architect wants to do is two things, and it's already in Article, I believe, 2.2, is that they need to perform in accordance to the standard of care. And the standard of care would mean that in your design, you would want to make sure that you are covering life safety issues, accessibility requirements. And then the question comes in, does zoning fall into the same thing as far as a life safety and accessibility? Zoning, I don't really look at zoning, because we're talking about toxins here, as necessarily an issue potentially. I mean, it could be because we know that maybe it's just a Superfund site and you have to have certain zoning of what you need to do to build. But I would not, as an architect, specifically call that out. Now, if I'm representing an owner, what I'm going to do is I'm going to take the B101, I'm going to make sure it says that in addition to the conforming to the standard of care, you are going to comply with all governmental requirements, and then define the governmental requirements that should state things like codes, regulations, statutes, and otherwise. And that type of encompassing language will then bring in life safety, zoning, and accessibility. So when we talk about this first question about should they promise, the likelihood is if you're going to be, as an architect, getting into a contract with a sophisticated owner or an owner that has an attorney that will do this, is by agreement, you're probably going to be required to. A good owner is going to say, I don't want in addition to my architect performing in accordance with the standard of care, I want to put a little more specificity that says they're going to comply with all codes, statutes, regulations, governmental orders, and otherwise, which would include these things. So is there something
in the owner-architect agreement that already kind of says something like that says that the architect is responsible for meeting codes?
Now you're asking me to go back to my eidetic memory, and I'm not sure.
Okay.
I can pull that up. But,
No, you don't have to pull it up.
So, and what happens is, and I will say this, like, so we talked about this right before the call started, that a lot of you guys listen to my lectures without my slides. And so when I go through the B101, my slides have the provisions on the screen. So what I can't remember is if there's a specific language that says architects shall comply with governmental regulations. I could pull it up over here if we want to, but the point is that it will not be uncommon, whether it's the AIA contracts or other ones, where an owner will require more specificity than just simply saying the architect shall comply with the standard of care. And in that specificity, like I said, you're normally going to see architects responsible for complying with all codes, regulations, et cetera, et cetera. So,
and I think I know the answer to the next question, but should the owner or the architect be responsible? Forget about the contract, but should the owner or the architect be responsible for hazardous materials that are found on site?
Yes, and in fact, what I would do, yes. So the answer to that is yes. And what you want to think about it, and this
yes,
is
yes for the owner, or yes for the architect.
The owner should be responsible for what's on the site, and how you need to think about it, whether you're an owner, whether you're an architect, or maybe some of you guys eventually go out there and you'll be working for a general contractor, is the owner has responsibility for what's there, what exists, and because you came to the site. So whatever's there, the owner buys it, they owns it, and they have to be responsible. Now, how it's removed, what happens from that is going to be spelled out probably in the owner-contractor agreement. But yes, if it's the owner's land, they own the land and they own the crap that's in the land. That's the one thing you want to think about. The architect, where its responsibilities with respect to toxins and hazardous materials is going to be is if the architect's designs require that in the construction of the project, they perform services, or the contractor must then bring hazardous materials on site. And it could be that the design of let's say you're working on a facility or a plant, that the actual technology that you're using has to have certain chemicals to clean. Like I do a lot, I've done a lot of scrubbers for coal-fired power plants. And so in those AQCSs and the SCRs, those scrubbers, there are chemicals that are used in the technology to remove the particulates. That's part of the design that the architect brings. And so if there are toxins or wastes that come from the parts that were put into the technology, the architect would be responsible for that because they've brought that in the design. And then the third area, again, if you're working for a contractor, the contractor is going to say, I brought these toxins in because the drawings told me to do it, so I'm not responsible for the fact that the toxins were brought in. But if the contractor is unsafe in how they manage it, the contractor is going to be responsible for the spill. Or if the contractor has generators on site, or that using diesel and one of those generators starts leaking and now there's toxic and hazardous materials and waste going into the land. So anything you bring to the site, the contractor, or your design is brought to the project, you're responsible. Anything that exists on the land, the owner's responsible.
But the architect would not be responsible, even if the architect called for a certain kind of solvent to be brought into the project as part of the process for the factory. The architect would still not be responsible for anything that, for handling that toxin or that hazardous material. That would still fall to the contractor.
Correct. Now, what would happen is, let's say that there's some toxic material that's part of the design for cleaning, scrubbing coal or exhaust, and there was maybe a different technology available, but now there's this dispersal of lime or whatever is being used, and people are injured, and there's lung problems and everything else. Because, like I said, we live in America, everybody's going to get sued. And the argument that's going to be made against the architect was, you use this technology, but you could have used a different technology and yours wasn't the best one. Now, that's going to be a weaker argument, because really the cause of the spill here was the mishandling by the contractor. But I wouldn't expect that the architect could just get out on what's called summary judgment, meaning I have no liability here, because their designs did call for that. And what often I will add into my contracts as an owner is I will say architects shouldn't be designing anything with toxins or otherwise. And if they do, they need to have a conversation with the owner so that there's proper protections put in place.
Okay. So for our next question, an architect
And
for firm.
wait, one real quick.
Oh, no, go ahead.
Quick to say.
No, of course.
Eric put in the chat, said looked at to 10.6. So yeah, Article 10 of the B101, I do know that has to do with hazardous materials and who does what, and if there's hazardous materials found. And I think it's also 10.3, who raises their hand and who doesn't. So those are relevant provisions you got to look at.
Excellent. Thank you, Eric. Thank you, Michael. All right. Our next question, an architect for firm A served as project manager for an award-winning large government building project. The architect, having left the previous firm A to co-found firm B, is responding to an RFP for a new large government building. Can the architect include the previous project completed for firm A in the past experience section of the RFP submission?
So the answer to that, I would say, and I don't think this is necessarily a pure architectural design legal question, it's more about experience. I would argue that the architect, yes, can put down that as past experience. Now, what you want to do, and RFPs and how that process works, normally you're going to have a written submittal. Sometimes if the project is big enough, and here if we're talking about a large governmental building, there may be an oral presentation, a dog and pony show. And in that instance, maybe the discussion gets into where you worked on it. I don't think that a representation by an architect, especially because they were a project manager, somebody that was responsible for overseeing the design side, the project construction, the delivery, the skill set that they're bringing, because people move jobs all the time. And if you had to leave your experience on the doorstep of your last firm, then what's the point of somebody hiring this experienced architect for, or in anything?
Right.
As an example, for me, when I go out and I do presentations for my clients, like as you said, I came to my firm, Perkins Coie, 3 years ago in January. So I've been here for like 3 years and a couple months. I have 25 years of experience at another firm doing high-end construction projects. And all the time I tell them I worked on this type of project, this type of project, this type of project, because it's my experience and that's how I get my work. So I don't believe that there's anything wrong. Where you want to get into some, where questions become a little bit more dicey is how it's being represented. Is the architectural firm of the new architectural firm saying that they designed it, as opposed to saying, our team's experience includes working on A, B, and C, as opposed to we built this governmental project. So you want to be, in your responses, you want to be kind of careful in how the firm is responding, because remember that it's being submitted on behalf of the firm. The other thing that you also want to be, and I had this project, I told Michael when he sent me this question, I had this come up. My joke was kind of, hopefully he didn't take the drawing. So I'll give you, this case was long time ago. I'm not giving away any names or otherwise, but I was retained by an architectural firm outside of Philly. And they were, one of the things they did was high-end themed restaurants. So like, remember like Planet Hollywood, and this was back 15 years ago when these kind of themed restaurants, there was like Cafe Rainforest.
Rainforest Cafe, yeah.
Rainforest Cafe, yeah. So they had designed a restaurant for New York City based on being on the planet Mars sometime in the year 2100 or something like that. And so it was a themed restaurant. And the primary lead project manager architect that had worked on all the designs decided he was tired of working for the firm. They were working on a project in the Chicagoland area, and it was going to be a repeat of the one that they had, this themed restaurant that went up in New York City. And so he took the drawings with him, opened his own firm, had a small little shop, and had all the drawings that he had on the project site on his computer. So he effectively stole drawings that did not belong to him. Now, he had designed them, but he had designed them as he had worked on them as the employee of a firm, and it was the firm's drawing. So even though it came from his head, his idea, and his working on his CAD system, he did not own them. And so what ended up happening is the project was being developed by the new company for this new project. My firm went in and we represented the architectural firm out of Philly, and we went in to try to get an injunction because they were infringing on our drawings. And we then brought a direct action against this former client of ours. He didn't have a non-compete or anything, but we said, you are stealing our drawings. And so that was an intellectual property case, not a design case, but it was part of the intellectual property. They were the instruments of service that he did not own. So this project manager pitching that he has this experience hopefully isn't also saying, and here's my design for it, and you can use that, because that's where you get into big problems.
Got it. Yeah, and I'll weigh in also. The AIA Code of Ethics, you guys can Google that, kind of weighs in on this as well. And what it says is that an employee from firm A can use the work they did for firm A in marketing purposes in firm B, provided that they ask first, and that firm A is supposed to grant them permission unless there are confidentiality issues somehow associated with it. But they're supposed to grant permission, and firm B is supposed to ask. Firm A is obliged to say yes for marketing, and this certainly falls under the marketing since you're trying to win the job.
Yeah.
All right, next question. Is it required that the AHJ, of course, for those of you guys who don't know, that's the authority having jurisdiction. So that could be an elevator inspector, that could be an OSHA inspector. Is it required that the AHJ issues a certificate of occupancy before the architect certifies substantial completion?
So this is a question that's going to come down to what's negotiated in your contract. There are a lot of times where you're going to have language that specifically says that substantial completion, and remember, substantial completion, while it's certified by the architect, is really a term that's more applicable to the contractor, because they're the ones that perform the services. At substantial completion, many things are going to trigger. Their warranties kick in. You as the owner will have to release retainage. There's a handover of responsibility. The assumption of risk that the contractor had with all the four corners of the project site is flipped and turned over to the owner, because the owner can now occupy the space. And so what happens is an owner will often come in and say, in order to achieve substantial completion contractually, you must have a certificate of occupancy that's issued by the AHJ. And the architect, normally in the process, is going to be the entity that's going to be certifying substantial completion. So if it's contractually required that there is a certificate of occupancy for substantial completion, the answer is yes. Now, what often happens in the negotiations that I get into is the contractors will refuse to have that as an obligation or requirement tied to substantial completion, because what they will say is, hey, I've been working with the architect. I'm not worried about the architect certifying substantial completion, but I may have this rogue bureaucrat that wants to do stuff and come in and check a bunch of boxes, and now I'm going to be delayed in releasing my retainage and getting the project closed up, and I have to wrap up my books and everything else. And so I don't want it to be tied to the certificate of occupancy. So what will happen is it won't be seen in the architectural agreement. The owner-architect agreement is going to say, you architect have a responsibility to certify substantial completion. Substantial completion will be defined in the owner-contractor agreement. And then in that provision in Article 9 of talking about what substantial completion is, it may or may not require that certificate of occupancy. I'll give you one example where I've run into this. So out in Virginia, the county of, I'm blanking the county right at this point, but Virginia has some very quirky statutes. And so these are some large scale projects that I've worked on, but in this one county that we've had to deal with this is, not only does the AHJ by statute must come in and issue the certificate of occupancy before substantial completion. So in that instance, it's not even up to the owner or the contractor. It's a statute that you have to comply with that jurisdiction's requirements. Not only does that AHJ come in and say, I'm going to issue certificate of occupancy, but they can come in and say, you haven't fixed the roads properly. You haven't put your landscaping together. Your water retention system isn't sufficient. And they can make assessments based on what they see in the drawings and what they believe complies for substantial completion. So the architect may say, you've done great in your remediation of the roads where all the big heavy trucks were coming in. You've done the right landscaping and your water retention system's fine. I would give you a certificate of substantial completion. And the AHJ can say no. And in that instance, the contractor then has to do whatever the AHJ tells them to do. And so it actually can be quite expensive for the owner. And so what happens in that county specifically when we contract with the big sophisticated contractors is they require the owner at the beginning. They say, we know this AHJ can put more scope on us than we ever bid for. So if we get to the end of the project and they ask us to do things that wasn't in our scope, you must automatically grant us a change order. So it can be a kind of a dicey negotiation because you have no idea at the beginning of these large scale projects what this AHJ will do. It's the only one where I've run into it where it's really specific and how much power the AHJ has. In other jurisdictions, like here in the city of Chicago, you self-certify. So you don't even have to worry about an AHJ there. And so therefore the certificate of occupancy is less relevant. So it just depends on from jurisdiction to jurisdiction, and depends on the contract of what the language requires to achieve substantial completion.
And so in the vanilla, AIA owner architect agreement, and I'm sorry, owner, all the A201, the A101, in that situation, is there anything that requires the certificate of occupancy to be issued before substantial completion? But it is typically done. Is that what you're saying? But there's nothing requiring it?
No, I would say that there are, I would say fewer than, like, I would say less percentage do they require a specific certificate of occupancy prior to substantial completion. And it's for both sides, because in many places, even before you have, so many jurisdictions have gone to self-certification. What the owner wants to do at substantial completion is to have the right to use the facility for its intended purposes. That's what substantial completion is generally defined as, a kind of generic in most contracts, that the building or the project is fit for its intended use and purposes. That's your buzzword. If you're in a jurisdiction where it says in order for you to use it, you must have a certificate of occupancy, whether it's a temporary, so a TCO, or a full certificate of occupancy, you would want to require that. But in many jurisdictions, that's not even required to allow preliminary occupancy, somebody to start working on things. Lots of projects, if you take a high-rise condo building, they may have people that move into let's say it's a 9-story building, you may have people that are working and living in the top 3 floors as you're finishing the other one. So the whole building isn't completed, and there you wouldn't have a full certificate of occupancy, you would have partial occupancy. So I would say normally you're not going to see it tied to a true certificate of occupancy, but it does happen.
Got it. Okay. Who is responsible for obtaining information from the municipal sewer authority to locate an easement? Is it the architect, civil engineer, mechanical engineer, or property owner, or someone else? So let's assume we're building a building and there's an easement going across the land, and it has a municipal sewer for it could be a sanitary sewer, let's say. So it's for the toilets and the sinks and so forth. Who's responsible for figuring out where that is?
So traditionally, that's going to fall to the owner. What the owner's going to do is they're going to ask a civil engineer. They're going to retain a civil engineer to come in and do the proper surveys. But the owner ultimately has the responsibility, especially if you're looking at the contract with the architect or the contract with the contractor. The language of the agreement says that the owner is responsible for legal title, surveys, soil samples, those types of things. Now, and that's at the first level. Depending upon the sophistication of the owner and how they want to handle things, they can, of course, contractually shift that obligation onto the architect, so that the architect would then, in that case, be retaining the civil engineer and retaining the soil people to go in and look at the soils or what have you. But normally you're going to see that the owner's responsible for getting those types of documentation, both legal descriptions of the site, finding out what the zoning is going to be, and finding out what conditions exist. What you'll also see in the contract, because most owners don't have that skill set, they will have the responsibility, but you'll see language that says the architect will assist in that. And so the architects maybe get paid to go out and file the papers and fill out the forms, but it's still ultimately the owner's responsibility. And then the architect would have the ability to rely on the information that's provided to them.
Okay, so now the building is going to be built. They know where in the drawings, we know where the easement is, but the building is going to be built. and or it might be built, but we want to make sure that the sewer can handle the additional sewage coming from the building. Who would be responsible for obtaining the information from the municipal sewer authority to determine the capacity of the sewer, so that we can make sure that we can link to it? Would that be the architect or the civil engineer, mechanical engineer, or property owner?
Yeah. So in that, again, for that one, it's flipped. So now you're looking at the design obligation. So the first is kind of locations, what exists before the project started. And so those are surveys and titles to the property and all the easements and stuff. So that's the stuff that the owner can gather on its own. Now we're getting to a situation where we say, okay, this building is going to have this much capacity, this much discharge, this much this, whatever it might be, and it needs to make connections into the municipal sewer lines or water lines or power lines or gas lines or all the other different types of utilities that will exist in the street or up to the property line. And now the design of those connections will fall to the architect, or in certain instances, the civil engineers probably could be tied in, and it depends on how the contract is put together as far as, does the owner retain the civil engineer, which is often the case, but not always, or has the owner said to the architect, you retain the civil engineer? If you remember the B101, it says the basic services, capital B, capital S, is for architectural, structural, mechanical, and electrical. And it does not include civil. So civil would be something that would fall under, and if you look down as far as who's providing it, you're going to say the name of the architect's subconsultants, and then you look to the next section, it says the owner subconsultant, and there's actually a section in there that says civil engineer. So the AIA contract is structured such that you would normally look to the owner to engage the civil engineer and bring them on board. So ultimately, the responsibility in those drawings that are prepared by the civil engineer and handed to the architect says, owner, I can rely on what you gave me because your engineer did that. But as far as the design, whether it's the architect retaining the civil engineer, the owner retaining the civil engineer, or whoever, these are the second part of the question for capacity and how the connections are, is a design question. And so as a good owner, you're going to place that obligation on the civil engineer if you're directly in contract with that. Or if you've passed that responsibility of contracting with civil engineer to the architect, you're going to place that on them. So think about it again, a little bit like the brownfield question of toxins. The land and what exists in the land, whether it's dirt and crap that's in the land for the toxins or the location of things, that's the owner because they own the land. Designs that go in or things that you bring to the project as your skill set, so here the design, are going to go to the design professional and their responsibility.
Thank you, Michael. And there's a lot of confusion actually among the community about the civil engineer because, well, for two reasons, really. One is that the architect it is not unusual for the architect to hire their own civil engineer. It is not unusual for the owner to hire their own civil engineer. The owner's civil engineer would be responsible for doing things like identifying where the easement is. The architect civil engineer might be responsible for determining the water flow into the sewer. Right. Although that would be for a stormwater sewer. For the MEP engineer would be more likely to do it for the sanitary sewer, as I described before. Those are sometimes the same civil engineer. Some civil engineers actually overlap quite a bit with structural engineers. Some structural engineers will do subsoil foundation stuff. Some civil engineers specialize in the kind of structure side of foundations, and some civil engineers specialize in hydrology or more than one thing. So there's a good deal of confusion, and it's one of those places where you have to be comfortable with positive ambiguity. It could be the same person, it could be different people, and the most important thing for the community to know when they're taking these exams is that the owner's civil engineer would do stuff that's, as Mike said, it's existing. The architect's civil engineer would deal with content as it relates to the design.
Yeah.
All right, go ahead.
Well, I was going to say, and one thing is, as the architect, because whether it's a small project or big project, the owners, especially on smaller, the unsophisticated owner is going to think like, oh, the architect's going to do everything. They're going to do everything, including whether it's civil for drainage or sewer or mechanical or whatever all of that is. And part of your job is educating the owner as to what obligations fall to them. And that's why the B101 is structured the way it is. I mean, it specifically says civil engineer in the trades or the design professionals being provided by the owner. And so you can point out to them, because you may not want to have those responsibilities, or you may be able to want to be able to rely on somebody else to do that. As you get more into the higher level, more sophisticated projects, for example, I represented for many years Navy Pier, and I was responsible for their centennial renovation. So it was about a $300 or $400 million over a period of about 7 years, the renovation of all of Navy Pier. And the project manager, who an old classmate of mine at Notre Dame, another architect, he said specifically, as he was one of the senior guys of head of construction at Navy Pier, said, I do not want to be responsible for any of the design issues. So I'm specifically saying to the architect, you must figure these out. And if you think about those who are unfamiliar with Navy Pier, it's this quarter-mile thing, but that sticks out into Lake Michigan, and it's built on pilings. It's not built on ground. It's built on pilings, and some of them have been there for 100 years. And he's like, I don't want to have any responsibility of what's below ground. I'm going to pass that off to the architect. The architect's going to be responsible for hiring the civil engineer, the mechanical engineer, do all the surveys, everything. So they would be responsible 100%. And when issues came up, it was actually cleaner for the owner, because they said, we didn't give you any of this. You did it all yourself. So you as the architect need to kind of be aware, what does my owner know? What do they understand? What are they asking from me?
And when you say it was on the architect, that doesn't mean that if they found that there was a rotted pier that had to be replaced, it was on the architect to pay for that. It just meant it was on the architect to identify that and figure
Correct.
out what to do with it.
Yes, and not surprisingly, like as-built drawings that existed for Navy Pier, either they didn't exist or they were wrong. And so what you don't want to have is the contractor starts digging a hole or putting something in and saying, hey, your as-builts are wrong, so owner, you need to pay me more money. Well, what happened in that instance is, let's say it's $1 million change order because the contractor's relying on a set of drawings that were provided to it. In a normal instance, if the civil engineer had screwed up, if the civil engineer was retained by the owner and they had screwed up on what was underground, the owner would pay that $1 million. But in this instance, Navy Pier said, I don't want any of that responsibility. You need to make sure that these as-builts are right. So when the contractor comes back to us and has a claim because the as-builts were wrong and they had to redo something, that falls to the architect or the civil engineer, and your insurance has to cover that because we gave you this specific design and investigation responsibility. It doesn't happen normally that way, but this one was a big deal for this client.
And something that's been rattling around in my head for about 20 minutes is you said that in Chicago, the architects self-certify the
owner self-certifies.
The owner self-certifies the certificate of occupancy.
Yep.
Do you ever run into trouble with that?
I have not yet, but that's, that
seems we'd all like to self-certify. Now I know there's no corruption in Chicago, but we'd all like to self-certify. That would be amazing.
Yeah.
As owners. Okay.
I mean, the owner, you want to think about it though. The owner doesn't want to take the risk. I mean, self-certification is great so you can get in, and yes, people can cut corners, but then if they do get caught cut corners, then they're responsible. They can't look back to the city and say, hey, the city certified me. So,
but what if they're building it on spec? Can they self-certify and sell it to someone and say, well, that's not our problem anymore?
Yeah. Well, no, they can't say it's not our problem anymore because they were the ones that certified and they sell it. So they still have to, it depends on, what the transactions are. And you want to make sure that your real estate lawyer says that, I'm not taking this as is or whatever it might be. But in fact, I'm taking it based on reps and warranties, and you represented and warranted to me A, B, and C. And so there are protections you want to have in that sale. But yeah, that's what happens here.
Interesting. All right, and finally, in what phase of design does a constructability review happen?
So my question to this is this because you have in the next one, is it design build or is this a standard?
Let's assume it's standard design bid build first.
So what's going to happen in that is the true constructability, as I think about it, is that review is going to be done by the contractor. And that's when they come in and they look at the drawings and before they sign the contract, and there's language in the the AIA A101, or I'm sorry, the A201, that talks about that the contractor has reviewed the drawings and made sure that they can build from what they've seen. So that's the constructability.
So that's in bidding then.
That's going to be in the bidding phase. Now, you can make the argument that part of the responsibility of the architect from SD to DD to CD is that their designs are going to be constructible, but they aren't doing what I would consider, and legally, when I think about constructability review, I look at that as that's an action that the contractor takes, as opposed to the architect making sure what they're designing can be constructed. So,
and if it's design build, when and who would do constructability review? Would that happen all throughout?
So in the design build process, that's going to be as the packages are released. And so what you're going to think about in the design build, because you're fast tracking and shortening everything up, is that you're going to be releasing certain packages while the rest of the design is moving forward. So if you're a fully integrated design build firm, you're going to be working hand in glove with your design and construction team while the drawings are being done. If you are a joint venture design build firm where you have an architect on one side and you have a contractor on the other side, it's going to be happening, but it won't be necessarily as symbiotic, because you're going to have the design team that's going to be then issuing drawings internally to the contractor to make sure we're moving along. They'll be having project reviews and internal reviews. But one of the things that the architect or the design build team should have done is they should have their own internal review schedule that may not ever be published to the owner, that shows when they're going to be doing touch points, when they're going to be reviewing drawings. Now, what I will do on some of my large scale EPC, which is engineering, procurement, and construction, which is kind of like design build on steroids, where the design is more engineering, like a project, like a production plant or some type of facility where it's not architecturally driven as much, but more as the functionality of the facility. If I'm representing an owner and we're doing it as an EPC, what we're going to have, not only are we going to have, we know that the EPC contractor, the design build contractor, should have their own internal schedule of when they're having their touch points, but the owner is also going to obligate the design build team or the EPC team to allow the owner to come into their project building, their design studios, and do their own constructability review. And that depends on the sophistication of the owner. Sometimes the owner will have their own engineering company, their own engineering team. And so there's going to be sometimes where there will be touch points between the design build team. The owner pops in and has in and out. They're not going to be changing the design, but they're going to be making sure that we're within budget and kind of overseeing it. And so that will be built into the language of the contract as the packages are released. So we got, we have the underground package, we have the steel packages, we have various electrical packages, plumbing packages, the MEP that comes out. All of those things will have their own design review schedules and constructability schedules.
And when there's a construction manager, and I know there's obviously different flavors of construction manager, but typically a construction manager is brought in near the beginning, sometimes often before the architect, and they're tasked with feasibility, cost, and constructability. Is there a formal place when in the process where constructability review happens, or does it happen at the end of each phase when the architect kind of shares it with the construction manager?
So again, I think like you said, there's different hats that construction managers wear. So there's your construction manager as an advisor, your construction manager at risk, which ultimately then just basically becomes a general contractor. And so if you're a construction manager advisor or sometimes an owner's representative, again, it depends on the level of requirements or sophistication that you want your CM to do. So I'm working on a $230 million multi-use condo, residential, retail parking structure or development that we're doing right now. And we have a nationally known construction manager firm as an advisor. So meaning as an advisor, they won't enter into any contracts with any trades. And they will be doing, based on their scope of work with the owner, limited reviews, but they will not be doing constructability reviews. What they're going to be doing is they're going to be doing budget reviews. They're going to be looking at high-level design intent reviews to make sure that it's within the liking of what the owner wants for the ultimate scope, but they won't do constructability reviews. There'll be another type of owner's rep or construction manager still on the advisor level that may have their own engineering teams or contractors that will do, again, as the package is released in a design build, or if it's design bid build, it would be more, it'll be before the bid process, they'll be more kind of involved. They will have constructability reviews because that construction manager as an advisor has the team to do that. And again, that would be that example that I was talking about is owners having touch points. That would be the owner's representative that have those touch points with the design build team or the design build person. If you're at a construction manager at risk, that what you're going to see normally that will be much more in the design build linear fashion, although they can come in more in sometimes in design build, but it's more going to be in the design bid build concept. And they will be having touch points during the design. And again, they'll be doing constructability reviews, they'll be doing budgeting reviews. The contracts that you're going to see do not normally have an identifying when those touch points happen. And so what you'll want to do, again, depending on your role and whose hat you're wearing, whether you're working for the CM, whether you're working for the owner, whether you're working for the design team, is you may have your own internal schedules, and it depends on how sophisticated the project is. If it's just, putting up an office building, the constructability reviews and what the construction manager at risk is going to do is they're going to say, oh, you're using this truss system. I could do it cheaper for this. So it's going to be more value engineering concepts. But if it's a highly sophisticated technology thing, they're going to say, let's work on this technology, and this is how it works. And I'm going to bring a lot more than just straight VE to the project. So a lot of it depends on, and as a result, you're going to want to have more structure in the schedule of when those touch points happen. And so a lot of it depends on what the ultimate project is.
And so following up on that, there are 3 flavors of construction manager. And my sense is that the likelihood of using all 3 is not equal. So if you have construction manager as advisor, construction manager as agent, construction manager as constructor, which is also, as you mentioned, called construction manager at risk.
Yep.
If there are 100 projects that come across your desk with a construction manager, how many are in each of those 3 baskets, approximately?
So I would say the CM at risk or the CM as
as constructor.
As a constructor, I would say that probably falls into probably 20%. It's a smaller percentage. It's interesting how many people still are wedded to the traditional design bid build practice where the contractor doesn't come in until a later date.
No, I mean, I'm sorry, I didn't make myself clear. Because design bid build is still like 55%, I think, of projects, but of the ones that have some kind of a CM, one of those 3 flavors, of those, and if there were 100 of those, how many of those are in each of the 3 flavors? In other words, is one way more popular than the other 2, or 2 way more popular than the third?
Yeah, I think if there is a CM involved, the most is going to be the CM as an advisor, where they are going to be, which I consider as the middle level, where they are going to be acting as an owner's representative.
Oh, okay. Is that the CM as agent or CM as advisor?
I believe it's an advisor, isn't it?
Well, that's weird because there's one. So that's a very good question. This touches on something that's super interesting because, as you might imagine, NCARB has their own kind of language, and their language is based largely not on the law, but their language is based largely on one particular book, the Architect's Handbook of Professional Practice. And there are two CM contracts out there that the AIA produces. One is called CM as advisor, but I think it's also used as CM as agent. It's used for either. And then the other is CM as constructor. So there are 3 categories in the Architect's Handbook of Professional Practice, but as far as I can tell, there are 2 categories in the AIA standard agreements that are out there. So I don't know if you know anything.
Give me a second here.
Yeah, I don't know if you know anything that you can. But as far as NCARB is concerned in the exams, they kind of treat it like there's 3 different things when the AIA kind of treats it like there's 2, to the best of my understanding.
Hold on. Because I have this slide in one of my lectures. Okay, you are correct. So the CM as an agent is the middle one. Mm-hmm. And so what's going to happen is the CM is, you're right, and that's probably where I got, and you're right, there are 2 agreements, and one's called an advisor, and one's called as a constructor. And the advisor can wear 2 hats. So if you want to take a look at risk and who's carrying what, and where I think that if a CM is involved, where it's mostly seen is the middle one, which is CM as an agent. So the difference between a CM as an advisor and the CM as an agent, the CM as an advisor is going to be somebody that maybe will help you with bridging documents, maybe help you with design concepts, but they're not going to be involved in overseeing the project as it goes from day to day. They're going to tell you way back when, here's where you want to spend your money. It's kind of like a consultant, I would say, as a CM as an advisor, the way I look at it. The CM as an agent is going to be someone where I also call an owner's rep, and where I highly recommend in any project that's over, I don't know, a couple $1 million, I tell my clients, you should hire an owner's rep for this project, because not only are they going to be able to be a watchdog for the invoices that come in for the contractor, and they're going to be able to they're going to be the ones that are be tracking the invoices and doing the paperwork that you want to have to do. They're trained at it, you're not. But they're going to be a watchdog over the architect as well. But and they will be your agent with respect to approving payment, but they're not going to be your agent as saying, yes, you can change this part of the design or that part of the design. That's not what you want to have them do, but you're going to want to have them to be like a watchdog. And I haven't been on a project, certainly large scale projects that are over 20, 30 million, where the CM as an agent has not earned their fee as far as savings to the owner. So let's say that their fee is $1 million, they're going to save the owner $3 million. So it's so much worth the price. So I see that out of 100, I'm going to make a recommendation of that 90 times.
This is CM as an agent if it's sufficiently large. And is it still the architect with CM as agent? Is it still the architect creating the pay app and then the CM as agent paying it, or is it the CM as agent creating it and the owner paying it?
So when you say creating, what do you mean by that?
I'm sorry. The kind of I'm sorry. The contract approving it. So the contractor gives the payment app, the application for payment, typically to the architect in design, bid, build. If there is a CM as agent, does the contractor then instead give it to the agent? Give it to the CM to approve?
So what I do is all of my contracts say that application for payment shall be presented to the architect and to the CM as agent. So they both get that. And then I say, working in conjunction, it will be reviewed and approved, but the final sign off will be signed by the CM as an agent, because they're the ones that are directly communicating with the owner. And what you don't want to have is if there's some kind of wonkiness going on and the architect wants to approve it because they can get out of it, the CM as an agent may say, you know what, this may be a problem with the architect. So you want to, if you're representing the owner, obviously. Mm-hmm. Now the architect, if you're an architect and you're working with an owner who has a CM as an agent, you want to keep control as much as you can as that process. And there are many, many projects where the CM as an agent for the owner does not do the review. They just do a final kind of glance over at the end. And so the owner does not have their CM become as proactive as what I recommend. But I've done this enough times that I know that there are times when, and it's not that there's an architect that's intentionally trying to hide things, or a contractor that's intentionally trying to hide things. But if you can have that independent neutral, they can make sure that the project comes in fairly, of who's being allocated what or what have you. So that's always my recommendation. And I represent largely owners, to have them have the final say on that.
Okay. So fantastic. All right. Well, we have time. We went a little long, but that's no problem. We have time for one question. So while we're waiting for someone to raise their hand for their one question, I have a question. So Michael has done the Gummy Bear Factory.
I did.
And it's been rattling around my head since I learned that. Is the Gummy Bear Factory more interesting or less interesting than it is in my own imagination?
The answer to that
I probably should tell you, in my imagination, it's pretty interesting. I'm not a sweet tooth person, but I am fascinated by the texture of anything gummy.
Unfortunately, I wish I could answer it definitively, but I can't. So obviously, I saw all the drawings and specifications. We built the factory. I had many tours of the factory. It's huge. It's 3 stories, 3 floors of where they make them. And the size of the bays, or the floors of where they're making gummy bears, are roughly 1 by 3 football fields. So it's like 100 yards by 300 yards, and there's 3 floors of that. And But because of Haribo, and they're the number one gummy bear, makes the number one in the world. They make, by the way, they make over 100 million gummy bear or gummy type pieces of candy per day. And that's not just here in the U.S. That's in the world, worldwide, because they have factories all over the world. So they are very secretive about their process. And so my people and everything, I had many tours, and I have lots of pictures of these blank floors. And I see where the conveyor belts are and how they get to the warehouse. And I see all these, I have the kitchen, the giant place where the food is. And I swear to God, like we've all seen Augustus Gloop go up the tube in Willy Wonka in the Chocolate Factory.
Yeah.
I have seen those tubes they're not clear, but I've seen those tubes in the Haribo Gummy Factory where here's the kitchen where they heat up all the goo and they add the flavoring and the glucose and it gets pumped out and it goes over a pipe and then it ends up into this big giant room. I have seen all that installed. I have never seen the machines because I'm not allowed to go in there.
Wow.
It's very secretive.
Even their lawyer is not allowed to go in there. So if I were to claim that in that factory there is a gummy bear trampoline, you could neither confirm nor deny that, and we could just go ahead and assume that that's in there.
And on that, I have no idea what's in there.
On that, we're gonna ask Ellie to ask the one go ahead and ask her question.
Yep.
Thank you for taking my question. I have a question regarding if the architect submit multiple times to the city and he received the multiple comments and he wasn't able to get the permit. So what will happen in this case? Like he submitted more than 5 times to the city.
So the architect has prepared drawings. They've submitted the IFP's issue for permitting. And they aren't able to get a permit from the municipality to approve the drawings. Is that the question?
Yes.
So what the architect needs to do is they need to have kind of a deep dive discussion with in this case would be the AHJ, the authority having jurisdiction, as to what are the elements that are missing or potentially defective as to why they aren't allowed to get a permit. And those are things that the architect, going back to some of these questions, who's responsible for what, the second question about zoning and life safety and accessibility requirements, it would be expanded to the standard of care. And your standard of care as the architect is responsible for designing in accordance with the local codes and customs and regulations. And if the standard of care isn't achieved and that you won't be approved, the project can't be built. And so the owner's going to say to the architect, this is an oversimplification, but it's like, I don't care what it takes. You need to figure this out and you have to pay for it on your redesign because I'm not the one that's designing it. That's what the owner's position is going to take. The architect needs to go back to the owner and say, I appreciate that, but you might need to understand that in order to achieve permitting, I may need to add A, B, and C, and that's going to cost you another 20% or what have you. And you're protected as the architect. You're not responsible for paying that cost increase because, again, you're just complying with what's required by the local jurisdiction in order for you to get the permit. But the first step, once you have the permit denied, somewhere along the way, is you're going to need to have a meeting with that AHJ, the building commission, whatever, to say, what is necessary for us to achieve that? Does that help?
Yes. Is it written somewhere in AIA documents?
No, it's not. It's not specifically in the AIA documents. It says you need to have a meeting to find out why you're not achieving or not able to secure a permit. What the AIA documents say, or what most contracts will say, is that you're required to perform your services in accordance with the standard of care. And the standard of care says I have to design something that is constructible and that will be able to achieve a construction permit. And so if you are not submitting a set of drawings and specifications that they will issue a permit, a building permit for, then your drawings are not to the standard of care. And what happens, unfortunately, is sometimes you have an AHJ that's very particular in one spot. So AHJ may say this is fine, and his or her colleague may say it's not. So there's some part of human nature in that. I'll just give you an example, which happened to me in one of my projects, is we had a large scale facility that was going to have potential wastewater toxic water or not toxic, but the part of their process had water discharge that was going to go back into the normal sewer system. And during the design process, the architect met on numerous occasions with the local building codes and authorities, and everybody came to what was believed to be a proper design solution for handling the water discharge. Then the project was permitted. And then as the project became underway and as the local village came in and started looking at things, they said, you need to have this wastewater treatment facility that was going to cost the client another $2 million. Now, the owner went back to the architect and said, how did you miss this? Meaning, you're telling me that we have to have this brand new building. It's a separate structure that handles our water discharge. And part of the issue was we asked, because I was representing the owner, was there sufficient communications between the architect and the local municipality on what was necessary for the water discharge? And it was unclear whether it was or wasn't, but we did find out that there was a change in staff and a change in personnel. And so my ultimate position to the owner was, you have to have this wastewater treatment facility no matter what. It's going to cost you $2 million. You can't get around that because they are not going to let you to get up and operate. But whether we have a claim against the architect for failing to perform these services and what our recovery is not clear. And we ultimately came to a decision that the architect provided designs at a significantly reduced price, and we didn't go back after them for additional costs. We certainly wouldn't have gotten the full $2 million because we always had to put that in, but there was scheduling and sequencing things, and there was additional costs that we could have gone after the architect, but we didn't because it wasn't beneficial to the overall project and completion. But this was an instance where there were discussions, there was permitting, and then they came back and said, you need something more. So you never know, and you have to be very clear in your communications and your documentation as to what is wrong and why the HJ will not give you permits.
Fantastic. Thank you, Michael. So hire Michael or have him beat you in court. Good night. Get licensed. Bye, everybody.
Thanks, guys.